business and company names are not trademarks. This is one of the biggest misconceptions within the business community, but business and company names do not provide a right to use the name in trade. That's the role of a registered trademark, as you can see from abr.gov.au. Business names relate to state-based laws pertaining to operating a business, and company names relate to the Corporations Act 2001, which is federal legislation. Trademarks are governed by the Australian Trademarks Act 1995. So, what is a trademark? This definition comes from ipaustralia.gov.au, the government agency that is responsible for the Trademarks Office. And here's the definition from the Trademarks Act 1995. As you can see, the emphasis is on distinguishing the goods or services from one trader from another. And you can search the official Trademarks Register by accessing the Australian Trademark Search website. Registered and pending trademark applications, as well as other information, can be found there. What about unregistered trademarks? Registered trademarks give their owner nationwide protection. That means once you have a registered trademark, you can use it for your goods and services across Australia and stop others from using it. Because it's essentially property, you can license it, transfer it, and so on. Trademarks can be protected across 34 goods and 11 service categories, also known as classes, as you can see here, which is taken from IP Australia's website. For instance, apps and software are in Class 9, whereas paper, pens, and pencils are in Class 16. And there are 11 service classes. For instance, accountancy is in Class 35. Trademarks must distinguish the goods and/or services of one trader from that of another, as shown here again in Section 17 of the Trademarks Act 1995. There are 1,000 cafes in any one city, but we need to be able to distinguish one from the other. That's where good branding comes in, and a trademark is legal protection for a brand. So what makes for a registrable trademark? Well, here are some tips. To be registrable, trademarks cannot be descriptive of the goods and/or services they represent. For instance, Apple does not sell apples. So, an eyewear company called Just Spectacles or Just Glasses or Just Eyewear would not be protectable. Trademarks cannot deceive or confuse the public. For instance, you cannot use a famous person's name as a brand to represent a product or a service without their permission. A trademark cannot indicate that goods are from a certain geographical location when they are not. Trademarks for the same or similar goods or services cannot be likely to deceive or cause confusion amongst the public. A trademark search should be conducted before business and company names are registered when your client wishes to use that name in the marketplace. This is absolutely essential to ensuring their chosen name is not already a registered trademark owned by another party, and also to ensure it is available for your client to secure their own name as a registered trademark. It's worth partnering with trademark professionals for trademark searches and applications, which you can also add as a white label product or simply as a value-added service. Only registered trademarks can carry the registered trademark symbol. Here is the famous Radio City Music Hall in New York City. It's also an Australian registered trademark, and so is the word Rockettes, and that means that its owner has the right to use the registered trademark symbol whenever it promotes it on its website, in this Google ad for instance, at any time. Facebook is also protected in this country, as you can see from this search, which shows that the owner, Facebook, has 50 trademarks, all the way from its earliest trademark, which was Face in 2005, through to its most recent trademark, which is very interesting because we haven't actually seen it in the marketplace yet, but you'll see it shortly, and it's Bonfire. Registered trademarks make businesses more valuable. Registered trademarks provide nationwide protection, can be renewed every 10 years indefinitely, can be sold and licensed. Business and company names and brands have none of those attributes. Your client's trademarks might still be legally owned by the graphic designers who created them. The reason why this is because intellectual property is generally owned by the creator or author unless it is legally assigned to another party. And generally, simply paying for it does not mean that the trademark has been legally assigned to the client. We can help you in many ways. Just go to comoip.com/contact and be in touch.